website, you will probably find articles written on arbitration, mediation related to shipping and transport. So this is something which I am a believer on. And when I got the chance, when they invited me to speak, I said, why not? I'll be more than happy to do it. So I'm based in Singapore. I handle claims on my personal side, act as an arbitrator and mediator. So I'm speaking from the perspective of someone who's involved in shipping and shipping related disputes. The first question you need to ask is, why do disputes happen? Okay, my intention is to speak for about 20-25 minutes. I generally like to speak off the cuff, and subsequently I'll be happy to take questions. I believe the participants are from the industry, they have a lot of experience, and as much as I would like to share, I would also like to hear from them the experiences, and be happy to answer any questions. Now, coming to the topic at hand, the first question I think everyone needs to look at is disputes. Why do they happen? I think when we have a dispute, it is because we have different perspectives. We see the same things, but we see it differently. It may be because we're wearing different lenses, or we have different values. We have a different glass, so to say. I'm wearing a pair of spectacles. Might be tinted. I see from a different perspective. If you look, India is from a common law jurisdiction. The UK is from a common law jurisdiction. My understanding is common law jurisdictions tries to prefer an individualistic approach, whereas if you look at a civil law jurisdiction, it is more a collaborative approach. So what happens is, again, it is not me, it is together. So all of us are coming from different perspectives, different systems, and might be there's also a power imbalance. And the example I would probably give is, Mr. Trump is now putting tariffs. He's doing what is correct for US, but the other countries might say, listen, it is not in our best interest. So there is a power imbalance, and that is the reason, among other things, this is the reason why you have disputes. Your strategies are, you could avoid it. If it's a very small one, you don't bother, in the sense that if the effect of the dispute doesn't really affect you, you say, sorry, I'm not going to do anything. It will die away. Or even the effect of it is so minimal, you're not bothered. So the other way is to collaborate, in the sense that I will touch upon an ADR, which collaboration is the way to do it. We will go further on that. Or you compete. You look at your own position and you try to advance what is best for you. So what is alternative dispute resolution? It's basically an alternative to court process. The traditional way is, when you have a dispute, you go to court, you litigate. So there are issues with litigation, but if you can find a way to try and resolve it yourself, that is alternative dispute resolution. And you can probably use both collaborative or adjudicative methods. And the way you would probably do it is to negotiate. If you look at shipping or freight forwarding, generally what happens is the people involved are knowledgeable. So they will negotiate, they will try to solve if there are any issues. If they are not, then they need to look at other modes of dispute resolution, which can be a mediation, arbitration, expert determination, etc. And also, you can decide on where it is, but we'll come to that. So what is the problem with courts? The problem with courts is, if you want to go to the courts, you need to go, generally the right of audience is only to a lawyer. They are very important people in the value chain. So you need to engage a lawyer. There's a cost to it, the knowledge requirement, there's a procedure to it. So if you have an issue and if you want if you have a dispute which you want to resolve it, and if you want to go to court, then you have an issue of knowledge requirement. Some jurisdictions don't have a problem. They are pretty fast. In Singapore, if you initiate an action, you can rest assured within a year or two, it will go from A to Z, in the sense that the court will give a decision if you go to the High Court. But after that, you also have a right of appeal. So again, you probably get under 6 months or 1 year. So you have a time frame. Sometimes it can be lengthy. Insofar as India is concerned, my understanding is there is a lot of pendency. In which case, if you initiate action, I have actually involved in some actions in which we have not been even heard once for the last 4 or 5 years. So, for whatever it is worth, sometimes it may be, it might be worthwhile to consider a process which is faster. Cost factors, it is expensive. If you really look at the whole life cycle of the dispute, you have to engage a lawyer, you have to pay the court. If you really look at it, the time you're using the opportunity cost of the money which you could have recovered if there's a dispute. So all that, perhaps, there is a cost to it, which might make it pretty costly in the whole life cycle. Insofar as when you get a judgment, now you have to understand that most of the time international shipping is between international parties. We're talking of international shipping or trade. You're not dealing with the same party. You're dealing with a party, a counterparty, which is outside the jurisdiction. Unless there is some treaty, it would be very difficult to actually enforce a court decision or a judgment. So therefore, even if you have a judgment, it would be probably toothless if you can't enforce it. Ultimately, you have to understand is that you need to have the bite so that you can recover what it is. And perhaps, you've gone through the full process, then you realize you've really not got what you paid for. So to avoid that, you may need to look at other processes. Sorry. When you look at ADR, you could perhaps look at collaborative ADR, which means you collaborate with parties. That is, when you negotiate, you discuss with parties. But the problem with negotiation is generally parties look from their own viewpoint. If they're able to resolve it successfully, fine. But sometimes they are not able to resolve it because once you're looking from your lenses, perhaps you're not able to reach an agreement which satisfies both parties. That is when you go to a neutral third party facilitator, a mediator, who's trained to work with parties, who's trained to look at the issues from the party's perspective, try to find common interests, and then see if parties can come to an agreement which they can resolve it. Now, sometimes people feel that mediation is basically, cutting into half and paying. I think it is wrong. A skilled mediator can work with parties to really find the interest. And the common example, if you go for any mediation training, is to give an example of two daughters asking or fighting for an orange. The normal instinctive reaction you might find is, two children, let's say two daughters ask for the same orange, the parent will cut the orange into half and give to each party. I think if it is a mediator, he'll probably ask each daughter, why is it you want the orange? It may be that one of the girls or the daughter might say, listen, I wanted to make orange juice. The other girl might say, I want to make a orange cake. In which case, you could give the rind to the person who's making the orange cake, and you can actually give the inner part of the orange to make a juice to other parties. So here you find that both parties get what they want. So a skilled mediator will look at what are the parties' interests. He or she could also enlarge in the pie. But for doing this, there must be a continuing, what do you say, a working relationship. If it's a one-off relationship or you don't have a continuing relationship, it becomes difficult. And the other thing is a mediator can also ask hard questions if the parties have considered, everything. So if you look at the life cycle of a dispute, many a times people get worked up. They have not really looked at the downsides. So a skilled mediator could probably assist them, ask parties what they exactly want. The fact is, if every party knows exactly what they want, the world will be a better place. But sometimes they miss it, and so sometimes it gets problematic. So a mediator is important. He tries to do it. In shipping or international trade disputes, you generally see a mediator probably in the fag end, in that sense that whenever you have started litigation and there's a court mandated mediation, and that time it is, probably your lawyers are looking at it for what's the cost, what's the chance of winning. But I believe there is an importance to look at mediation right at the beginning before you have a hardening of stance, wherein you can still, enlarge in the pie and see whether you can work out a solution which, serves both parties' interests. The conciliation is some form of mediation, but the mediator is more involved, tries to assist parties to find a solution. Whereas if you talk about a mediation, the general practice in the international market is generally a facilitative mediation in the sense that the mediator facilitates discussion between both parties. So in Indian context, you will find Indian conciliation, which is there. So I think mediation and conciliation are similar. It's just the approach is a bit different. A mediator takes a bit more of a front foot approach to try and get parties to find a solution which they can live with. The reason I put grievance forum is because AMTOI has a grievance forum in which, if you have a grievance, you can get AMTOI, some of the grievance forum members, you can discuss and try to do it. It's all collaborative. You can talk about it. It is non-binding, but if you have an agreement, and once you have agreed, you can make a binding agreement. Uh, Again, Singapore Convention, there's the Singapore Convention on mediation. The problem or the issue with mediation is its effect once you have a mediated agreement. The normal way is you look at it as a contract, and when there's a breach of a contract, you sue. Whereas if your country is a signatory to the to the Singapore Convention, which is there for the mediation part, once you have a mediated agreement, and then you can enforce it as if that is a court judgment or an arbitration award. The other way is to go to adjudicative, wherein you get someone to actually give you a decision. Arbitration is a creature of the contract, wherein you choose an arbitrator or arbitrators to hear the dispute and give an award. They decide on whatever has been presented. Uh, it's legally binding, it's enforceable. Internationally, it's more formal than mediation. There are a lot of benefits of arbitration, which I will speak a bit later. But arbitration, the advantages, if you both cannot agree, because what happens if you look at shipping or international trade, parties are speaking, they are negotiating, they have already tried that. And since they are not tried, they would like to go to someone else who could probably hear it, touch on it and give a decision. So arbitration is something which will do it. The other alternative is you could also have in your contract something known as expert determination. Get an expert who actually does it. If in commodity contracts, if you want to know the price, you get an expert. And since contractually you agree, you say yes, whatever the expert says, we'll do it. The benefits compared to litigation is generally adjudicative ADR is faster and it's often more cost effective. If you look at shipping or if you look at international trade, you will probably find a lot of contractual disputes. One is cargo damage. There's physical harm to cargo damage. There are a lot of conventions. If you're doing shipping, it'll be Hague or Hague-Visby rules. Rotterdam rules has not come into force, but you look at the cargo conventions. Insofar as trade from India is concerned, if there's multimodal transport, then you have got this Multimodal Transport Act of India. So you look at those, and then obviously there's physical harm. You have which is provided by those conventions, and whoever is issued his document of BL, who is contractual party, he needs to do as a contractual party. Uh, there are other types of disputes of non-payment of freight, demurrage, and different. These are contractual issues. The unfortunate part of contractual issues is no one really looks at it unless it really blossoms into a very major issue. Insofar as cargo damage is concerned, at least you have some sort of a cap, or you have some sort of a standard trading condition by way of the international conventions where you have some protection. Whereas in the contractual issues, you do not have. The other issue is, in freight forwarding and NVOCC or all this intermediary class of business, you don't generally have a FD&D cover, which is available in shipping, in the sense that you could actually take a cover, a legal cost cover, so that you could seek assistance from the legal cost cover, FD&D insurer, to deal with disputes if you have a favorable chance of winning or defending the claim. So insofar as our trade is concerned, the trade which you all are involved, you would probably find that you will need to deal with your own assets or outside assets, and this might be pretty costly. If someone has not paid you, you need to go to court to do it, and you might find going and fighting that in court, if you're not properly set up your contract, might not be a viable issue. So if you have a contract, it is always better in the first instance to try and find a way to deal with disputes. I know that when you are trying to deal with doing business, you are not looking at this at contracts, but disputes will happen. Yeah, I have a dispute nearly every day or every week with my daughter. So my point is, when you're dealing with counterparties, you will have disputes, and it is best practice to agree on a process which both parties can and try and ensure they can resolve it. There are non-contractual disputes like, with a third party where you don't have a contract. Let's say you're a container which has got cargo and there is spillage from the container, which affects a third party. And that's a third party liability. You don't have any contract. Uh, and generally, what happens is you will look at who's in a better position. When I say that, you will probably look at which is the jurisdiction you should try and proceed against. You will probably pick and choose if you are in a better position to do it. If I want to arrest a vessel, like if there is an issue with the vessel, I'll probably pick and choose the jurisdiction where it's easy to arrest a vessel, where I can found jurisdiction, both to found the claim and secure the claim. So because there is no direct contractual relationship, you need to look at it and you need to plan to do it. Uh, the uh, the issue nowadays is courts realize that parties should try and solve their problems by themselves. So generally, you would find, at least in Singapore, I believe in India and all other places, at least the senior courts, the high courts generally mandate that parties consider ADR, and if they have not voluntarily considered, there may be cost sanctions, in the sense that once the court gives a decision, and if a party is able to raise an issue, listen, we suggested ADR, which could have been much cheaper, much more faster. It is possible to get a cost sanction against the other party, and costs in these type of disputes can be very high. The other thing is parties, if they are knowledgeable, disputes do happen, and they can always say, listen, let us try to resolve it ourselves. Let's look at the complete repertoire of dispute resolution processes. Let's negotiate, mediate, or arbitrate, or whichever way, and try to find a solution ourselves. When you have a dispute, it's very important that the original parties are involved. The fact is, and I have seen it many a times because I'm dealing with disputes, when a dispute is triggering an amount, or it takes more time, or it is more complicated, then the original parties are no longer involved, and then it becomes people get influenced by how much they have invested in the dispute. They get influenced by other things. But if the key person is involved in the dispute, sometimes the key person is able to think, look at the dispute from the other party's perspective, and try to find a solution where they can all live with. If you are insured, if you look at AMTOI, one of the requirements of becoming an AMTOI member is you have a liability insurance. And if your policy is triggered, you would generally be going to your insurers for indemnity or assistance insofar as your claim is concerned. The insurers take over the conduct of the claim. The problem with that is the insurers do not have any commercial relationship with your third party, your counterparty, so to say. So they will be guided by the facts. They will be guided by whatever is best for the claim. That might not intersect with what actually is required. It might be in parallel to say, but that's the way it is. So, if you are having third party involvement, it may also influence the dispute resolution path. They might say, listen, we are not looking for collaborative. We are looking at an adjudicative process. We want a determination because we feel this is better. Or they may also take tactical positions. They may use, try to initiate action in some other place wherein parties, would like to not defend or defend. So these are processes which are there. So third party involvement is something which you need to be aware. Also the amounts. If you have a claim of 5, 10,000 or 20,000 or 50,000 in Singapore or UK, I would probably say it is not worth the effort to fight, because the costs of fighting in litigation is much more. Having said that, in other forms of dispute resolution like arbitration, you have process, which I'll come to in the next slide. So what I'm trying to say is you also look at the amount. Sometimes the amounts are so huge, you need to fight because the amounts at stake are so high, and the amounts, to fight it also will be there. So I think, you look at the control of disputes. These are the general factors you look at when you're dealing with disputes. There are various processes, and in my view, arbitration is the best process insofar as the shipping and international trade disputes are concerned. And the reasons which I probably state is because parties are knowledgeable, they know the trade, they already negotiated, they have tried their luck. They have an initial ongoing relationship, they want to maintain it. If parties are unwilling to do it for whatever reason, there might be an insurer involved, the amounts are too huge, our parties are not willing to listen, then it is best to go to an adjudicative process where parties can do it. And also, you would find that invariably there will be an insurer for large claims. I think anything, if the deductible in the transport liability policy, the minimum deductible in the international policy is 2,000 to 2,500 US dollars. So anything above this amount, the insurers will take over. And then obviously, they will probably look at from their perspective, what is the best way. They might not look at your, what do you say, commercial relationship ongoing this thing. So, if you have an arbitration and if you can tell parties, listen, there's a faster and easiest way, why not? I think, in my view, this is the best way to do it. I'm happy to hear with parties on this, but let's keep it for later. Why arbitration? I think you can actually, it's a creature of the contract. You can have a process depending on the size of dispute. If you have $1 million dispute or a $10 million dispute, you probably want a more, what do you say, a process in which you can actually ventilate all the issues and do it. But if you have a claim of 25 or 50,000, you don't want to spend 100,000 or 25 or $50,000 size dispute. So you can have a brief version. And if you look at the LMA, London Maritime Arbitrators Association rules, you have a small claims procedure which has got capped costs, capped, what do you say, arbitrators fees. In the Singapore, they have an expedited procedure. So you can have a customizable process. And, you need to give and take. You can't have the best, but you can look at the issues which are there, try to tailor it for the dispute size and look at it. The other thing is, even if you litigate and you win, generally you don't get your 100% of your costs, and cost in international disputes is a big issue. In Singapore, where I teach in one of the local universities as an adjunct, I always tell the students that to look at the cars, the expensive cars, which are driven by two classes of professionals. You generally find that Mercedes and BMWs are driven by doctors and lawyers. So which means that you need to pay a lot of money to get assistance. So there's, so it all comes back. So there's a cost to it. So if you litigate, you may not get in jurisdiction, you generally get 650 to 60%. In arbitration, arbitrators are more happy to give a higher, recovery of costs, as long as parties have done that dispute, dealt with the dispute properly. It should be proportionate to the dispute. They should not argue something which is not there. So generally you find your cost recovery is better. So actual cost spends are much more lesser vis-a-vis litigation. I think the most important point, which is for international dispute, is enforcement. There is a convention known as the New York Convention, in which more than 155 countries have signed it, have legislated in their domestic legislation, and is leaving for public policy reasons in their which is provided in the New York Convention. If you get an international arbitration award, these countries are duty bound to enforce it. So if you get an international arbitration award which is seated at Singapore, it is very easy to enforce it in India. It's easy to enforce it in more than 155 jurisdictions. Whereas insofar as litigation is concerned, which I did tell you at the beginning, you need to have some sort of a treaty, some sort of a understanding between the countries to go in and try and to ensure that you can enforce it. Confidentiality is also one thing which most of the arbitration acts generally provide for an implied duty of confidentiality. My personal view is it is not good, but that's the way it is. Parties don't want to wash dirty linen in the public. So if you want parties to maintain this, you don't want to do it. So I think you want to keep it within the confines and not have an impact on your business or this thing. So arbitration is confidential, you can keep it. Litigation, on the other hand, is not confidential. And if you would like to avoid your names coming in the awards or on the judgments, then I think there's something we should try and ensure that litigation is not there. Otherwise, you would find judgments or different names. This is there, and you can actually come to it. This talk is, I must thank AMTOI for organizing this talk, and I took this opportunity to go look at the BLs which the industry, the multimodal transport industry in India uses. They generally use draft wordings which are suggested by the DG Shipping in the website, and in clause 25, it says, parties may provide for arbitration. In my last article, which AMTOI was happy to publish, I did mention you need to specify an arbitration clause, not that may do. People are generally following what is there. They don't specifically provide. For my clients for some of my clients who are there, I have suggested that they actually provide for an arbitration clause. And since they act thus, and since it's there, so arbitration is allowed, you could, as an AMTOI member, as parties in the industry, have an arbitration clause, a specific arbitration clause. If you don't have it, because you don't, it is not something contractually which you have agreed, you will not have to, parties have to agree. The problem, what happens is when you have a dispute, people then don't look at, they look at their position, what is best. Do they, if sometimes they'll say, oh, litigation is expensive. So I know my position is weak, but since litigation is so difficult, it's so time consuming, let us litigate and, parties may go away. So when you have a dispute, it is very difficult for parties to agree on contractual provisions, or to agree to vary to try and solve it. It is best to agree at the beginning so that you are bound by what you have agreed. Again, triple FAI, I have looked at clause 7 of the standard trading conditions. It does provide for an arbitration clause. Uh, my suggestion, they also said that, that arbitrators to be appointed under this clause shall be only appointed for the panel of arbitrators, duly approved by FFAI. My view is if it is between two members of FFAI, I have no problems of this. But if it is going to a third party, if it's a cargo interest and a member of FFAI, you may have a chance of attacking that this clause is not fair, because it's not, the process is not fair on that aspect. So I would probably say, again, it's please take it with a pinch of salt. Probably you need to ask the Indian lawyer, look at having a process wherein you have a representative from the complete industry. It could be a cargo interest and someone is there, and so it is not only from FFAI, and have a process which can be there. But anyway, it's a good start. You already have an arbitration clause. I would probably pray it's better to put a specific principle place, have a specific rule, so we can appoint an arbitrator much more faster and easier. So again, you have this which is there. I think you can probably do that way. What are the issues with arbitration? Some of the issues are formality. If you look at the bill of lading, the general practice is it's only signed by the carrier. So the arbitration clause is basically, it's a boilerplate contract in the sense that the country, clauses are put. No one probably negotiates with the carrier. If you go to a carrier and say, I want this, they will say, sorry, these are my terms. I'm not going to negotiate. So the formality requirements in some of the jurisdiction is it should be signed, it should be negotiated. So might be they take a very strict view. On the other hand, as far as India is concerned, I have seen judgments in which they have held it to be valid. So in some jurisdiction, you may not have it. Consent, was there a genuine agreement to arbitrate? In some jurisdictions, at least in the Middle East, the person signing an arbitration agreement must be a director, must be authorized by the board. So you may have issues there. They may take technical issues to do it. So that you need to be aware that, this is not the only way, this is not solves everything. There may be issues. So we need to find solutions as we go by. At some point of time, I will probably write, that there's a way to go. But like I said, everything will open a can of worms. There'll be always some. Human beings are actually very ingenious. They always try to find a solution. They always try to find a solution or create problems. So they might have other issues which come across, but we need to deal at it step by step. So yes, if you find a solution, there might be other problems, but I think still, with arbitration, you can actually try to solve it. Courts generally uphold arbitration clauses. If there is an arbitration clause, I think both Section 9 of the English Arbitration Clause and also the Indian Arbitration Act provides that a party can take a stay if parties litigate in their courts. The catchword is you should not participate. You should, at the first hearing, you should make you should object, tell provide tell the court that there is an arbitration clause. It should be arbitrated. And unless there are some public policy issues, generally most of the courts will give a stay and ask parties to arbitrate. That's something which generally the courts realize that it can be done. Uh, the feeling in most of the courts is let people who know the business do the business. So it's actually good for you all if to use that. Uh, Disputes, if you can prevent it, fantastic. But life is not so simple. You will have disputes. Yes. The best approach to avoid, if you can avoid it completely, then probably me and colleagues like me who are involved in the dispute resolution industry will be out of a job. Yes, but there will be disputes. I think we need to choose. Yes, you will have differences of opinion. You have differences of opinion within your family, outside your family, with international parties. It's because of different factors. It is your knowledge. Those we can talk, but like I said, disputes will happen. We need to deal with it. Choose the most appropriate resolution method. Better to do it at the beginning than later at the end. You can probably put a proper contract. Look at your, as an industry body, AMTOI or FFAI or anyone else, can look at it and say, listen, this is what we recommend. And what happens is, instead of spending money unnecessarily, you can deal with disputes more properly, more efficiently, and that can do it. My view, arbitration is the most or the best option for maritime conflicts or international trade conflicts or shipping conflicts. The reason is very simple. You are dealing with parties who are knowledgeable, who know the business. They want to have a continuing relationship. They have generally tried it. But arbitration also has the option to look at other, dispute resolution processes. Like if you initiate arbitration in, let's say, the LMA rules or SCMA rules, or even SIA, the institutional arbitration, you could, if you feel, ask for a stay from, you can request the arbitrator schedule, hold on the proceedings, and you can start mediation. So you have a arbitration protocol. The advantage again on this is, if you get a consent, if you get a mediation, if you are able to reach a mediation agreement, then you can ask the arbitrators to give something known as a consent award. And for the purposes of New York Convention, this is an enforceable arbitration award. So, so my point is, it doesn't mean, if you have arbitration, you could have multiple ways. It depends on the preference of parties, the sophistication of parties, how to do it. Sometimes you need to look at litigation because you need to form jurisdiction, like you may have, or in aid of arbitration. So to take security, you arrest a vessel and then you arbitrate what is necessary. So to aid of arbitration, you litigate. Or if you don't have an arbitration clause, or if the party doesn't have money, or if it's gone bust, so you may look at litigation. My point is, you look at all the methods, but as far as shipping is concerned, I think arbitration, it's more tilted, but doesn't mean that's the only way. And you can have a combination of all which is there to try and solve it. I think with that, I have come at the end of the presentation. I'm happy to take questions if you have any.
Absolutely. Thank you so much for that lovely presentation. It's been a bit eye opener and options what we've got. A whole lot of questions. I'm just going to read that out. Give me one more minute. I'm just trying to compile the last few questions, and I'll just start the sharing. You can stop sharing, sir.
Okay. Uh, okay. Perfect.
Okay, nice. That was wonderful, Jagan. Yes, amazing. I think you covered almost everything that people would like to know, and in how do you put it in very simple ways for, amateurs like us to understand what exactly is happening. So I'm sure we have quite a few questions. We had received a few questions earlier also from, some of our members who could not make it or have joined in but sent their questions in advance. So, Priya, whenever you're ready,
I'm
I'm
ready.
sure Jagan is always ready. So,
Here I am with my questions. I hope you all can see the screen.
not yet, nothing there. Ah, perfect.
So some of the questions which I had received before the event, before the session today, they were a bit generic. There were also questions on turnaround time, There were questions on green logistics, and there were questions also on what should be the sales strategy. So I have skipped those questions. I can't answer because our session today is completely going to be on the ADR related questions only. So that is why I've just taken up those questions. Some questions might be repetitive, but I'll just read one by one. The first question says why NVOCCs are reluctant for delivery against bank guarantee. I was not very clear on the question, so I hope um, Jagan.
And I'd be happy to answer this. This is not related to ADR, but I think the issue is, if you're giving cargo against a bank guarantee is basically a security which is provided to a carrier in return for delivery without original bills of lading. A carrier has an absolute duty under common law to deliver only against original bills of lading. So if by chance there is someone else with a competing interest, then the carrier has a potential claim for at least the value of the cargo. You take a bank guarantee, but even if you take a bank guarantee, sometimes in some jurisdictions, the bank starts to argue that this guarantee is not valid or it is for something else. So my point is, you need to ask, if you're not comfortable, why should you do it? It is not something in law you need to do it. But the accepted trade practice is you ask for counterparties is to give a guarantee, a bank guarantee on wordings which are comfortable on on with banks who have a good reputation. You don't want a bank to go bust. And if you are really comfortable with it, with at least 150% or 200% on the value, that 50% more is because costs of fighting the case. I did tell you, cost of fighting is not free. The cargo might be 20,000, but you will spend about 30 or 40,000 to fight the case. So you ask at least 150 or 200 or 300%, depending on the quantum of claim. I think they will take a commercial decision whether they want to do it or not. If the NVOCC is not having the wherewithal, you might say, why should I get involved? I will only give an original PL. That's perfectly acceptable. And it is not his problem. He has a duty to only deliver. But the general practice is to give a bank guarantee as long as you're comfortable. So it's a question of comfort factor. I hope that answers that question.
That's a very good explanation. Thank you. Mr. Irfan has asked, how does ADR contribute to reducing the legal backlog and promoting faster resolution for commercial disputes in Pakistan? Mr. Irfan is from Pakistan, I guess.
Yeah. Mr. Irfan, I'm going to be in Pakistan, I think 2 weeks, 5 or 10 days from here. So I would welcome an opportunity to meet you there when I'm in Karachi. I think the problem is not only in Pakistan, it's in India, it's in Singapore, in all places. I think the way you could probably do is, if you go to court, the court is meant to deal with all types of dispute. They have a duty, they are an organ of the state. They need to look at murders, rapes, different types of things, among which one of it is commercial disputes. And therefore, you might not get your line in the queue, or the queue number is not really fast. So you might have delays due to that reason. But whereas if you actually contractually provide in your contract that if you have a dispute, we will arbitrate, a specific thing, then you're contractually bound by it. And if a party doesn't participate, you can get a default award in the sense that you can probably proceed with arbitration even if the other party does not do it. The arbitrator will hear the dispute even if the other party is not there. He will look at all which has been argued and he'll give an award and which is enforceable. So one of the ways to do is, probably talk to your industry body in Pakistan, to have a sort of a clause. The best buying is to have some sort of an industry clause in Pakistan, or, if there's a dispute, we'll do it by so and try and get it. It's much more faster. You will probably say that once it starts, people will say, yeah, there are better ways to solve it, and it can do it. So I hope that answers your question. This obviously will reduce your legal backlog insofar as the shipping cases is concerned.
The next question is both for you and Haresh Bhai to respond. In what ways can professional bodies like AMTOI support and promote awareness about ADR among media professionals and corporate entities? Haresh Bhai, are you also there?
Yes, I'm here very much. And I had to ask this question on behalf of our members. And, how as AMTOI do we promote something like this and take it forward? I know we do have a GRF, but then it has to be a little beyond that. So while we are online, I'm asking for some free advice, I guess, for the association.
I think, okay, since I think you could probably, if there is, if parties want, you can have a common arbitration clause insofar as the AMTOI, the BL is concerned. The common wordings you use in the AMTOI BL, you could probably put an industry-wide wordings for it, and you can put it in a thing, and your members can use that in your, what do you say, MTDs, because the MTD clause, what as of now is everyone is promoting their own, or they're just leaving, a clause can be there, it's not put. That's one way to do it. You could also get some of your members to know about arbitration, and so that they could be considered for appointed as arbitrator. The normal process is, when two parties have a dispute, each party engages an arbitrator, and these two arbitrators engage a third arbitrator, or there's a third arbitrator which is appointed by an institution, and you have a binding award when at least two of these two arbitrators decide. In smaller disputes, it's only a single arbitrator. Both parties have to agree. If they don't agree, then you go to an appointment authority. If you don't have an appointment authority, you need to go to the High Court of whichever jurisdiction. So you can try to have facilitate, get this done. Have a, let's say AMTOI BLs, MTD BLs, not only your members, but also from the cargo industry. Someone who's looking at this saying, listen, why don't you be there? And then if there's a dispute, it's better the industry solves it instead of going to court. And I'm sure the pendency in India is not so good. It's you have the courts take so much time. So yes, this is something which AMTOI can consider. Probably 2025, you can think about taking it forward. I hope that answers your question.
We definitely will, and I'm going to need a lot of help from you, and not only help, but a lot of advice and how to take this forward, as we really need to do this for our industry and specifically for our association, and also we also have an extended board, so it'll also help us resolve other these kind of resolutions would help in beyond just multimodal. We have the EV, and if we can get all of them together, I'm sure a lot of problems may be solved without going to court. So yeah, it's a point to consider, and thanks for showing us the way.
Great.
Okay, my pleasure.
So the next question is, can a dispute be referred for arbitration although there is no provision in contract?
I covered this. Yes, you can actually, if parties can voluntarily agree post dispute, let's arbitrate. The chances are, at that point of time, parties will take a tactical position. They might decide, litigation is better. See, what happens is what is good for one party may not be good for the other party. Unless parties really have a dispute where they really want to solve, generally people take a tactical position. They look at what is beneficial at that point of time, and it might be difficult. Therefore, it is always better to look at arbitration in the contractual stage. Having said that, if you want to litigate, at least I know in Singapore, in the UK, in most of the other, even in India, I believe in the High Court, the courts, if you look at, they try to say that, listen, you need to consider ADR, and therefore you could propose ADR. Not ADR includes arbitration or mediation. I know that sometimes people do only a tick box. They need to show it to show good faith, but they're not actually doing it. But if parties really want to say, I'm proposing arbitration for these reasons, the court sanction, and if parties don't do it, there might be a cost sanction, then parties may be, motivated to look at arbitration. But that's not, the effective way. The effective way is to really look at it before. But you can try your luck, and if it goes from this thing.
So I'll continue the next one question after this, which is more of a continuation of this question. If a contract does not mention arbitration, can one of the company still insist to go for arbitration instead of going to the court? As in the one person has taken them to the court, and the other one can just keep saying that no, we should go back to arbitration
Or suggesting for arbitration to something, I guess.
after going to the
I,
court.
arbitration is a creature of the contract, which means that both parties have to agree. If both parties don't agree, you can keep on suggesting. Because you can't, then you go to court. There has to be an ultimate authority. Even if you have an arbitration, if it's seated as some jurisdiction, the court has final supervisory powers. So, like I said, tactically, someone will say, no, Indian courts are slow or it's costly. I will go for litigation. It will take 20 years. By the time this, people will forget. So you can suggest the only way is cost sanctions. In some jurisdiction, like in Singapore, I actually volunteer for all my clients. Let us look at arbitration because they're faster processes, they are quicker, cheaper methods to do it. And if by chance, because Singapore is also pretty fast so far as litigation is concerned, you can use the cost sanction. But if you don't have an agreement, if you don't have it's a creature of the contract, you cannot force parties to go for arbitration.
Okay, great. So, how can ADR clauses be effectively incorporated into shipping contracts like bill of lading, charter parties, or freight forwarding agreements?
To be very frank, I was pleasantly surprised. At least if you look at, I'm not trying to sell now, but now, I have actually said, arbitration for shipping contracts, bills of lading. So the last few years I've been doing it. I was pleasantly surprised. Some of the mainline operators are incorporating arbitration clauses. You look at PIL. PIL is one of the first top 10 carriers who have actually put a SCMA clause for arbitration. I think ANL Singapore Private Limited also have an arbitration clause, SCMA clause. Uh, some of the clients which I have actually recommended SCMA clauses, which if they are based in Singapore, I put a Singapore jurisdiction. If they're based in other jurisdiction, I put a different jurisdiction. That is for the seat. What happens is, because the party is there, we try to framework and try to do it. So I see that, if you have a contract and you bring it to the notice of the party, you can actually incorporate into contract. Like I said in the beginning, there are issues. The counter when the BL is endorsed, it goes to a third party. He may argue that, listen, I am not a party to the contract. I am not did not voluntarily agree for the arbitration. But the bill of lading contract is one of the unique contracts where the original shipper remains responsible for the performance of the contract. So even if you are sued by a endorsee of the BL, on the courts, you can in turn arbitrate against the shipper, saying, we had an agreement that only arbitration is there for failure agreement, and you can hold him to the contract. So if you want to incorporate, yes, you incorporate, put a proper clause, put it in the face, put it in your website, in your booking note, we are arbitrating, you put this, you make sure that everyone is aware of it. If you do it, it's fine. Insofar as charter parties is concerned, invariably you will find LMAA, SCMA, HKMAG, or SC Mani, all these common this thing. And it is generally accepted, which is there. Freight forwarding contracts, if you look at BIFA contracts, you're already provided for LMA clauses. For SLA, we don't find any what do you say, suggested clause, but I have suggested to clients to put a CMA clause because SLA is from Singapore. So Triple FA already has got an arbitration clause. So as long as you incorporate the STCs in your contract, as long as you bring it in notice, you can effectively incorporate it. The question is of notice. The question is before signing the contract, bring it to the notice of the party, ensure there is aware, and ensure that he has signed to the contract. Then you can hold him to the contract.
Great. So, the next question is, what are the limitations or drawbacks of ADR in international shipping?
Well, this is an interesting question. Sometimes what happens is, the party doesn't have money. Yes. And because the ADR has a process, it's not as quick as you'd like. So sometimes what happens is when there is, what do you say, someone is going bust, you have processes which are faster insofar as litigation is concerned, wherein you could try and pursue them and try to do it. But in case of ADR, because it's a creature of contract, because parties have agreed, tactically the operators might say, no, you first arbitrate. Once you get an award, we'll deal with it. There is no perfect system. I think you need to give and take. I think there are some drawbacks. There are some tactical differences, but parties might do it. They might try to say there's a public policy where it should not be done. Some jurisdictions, parties will not participate, and they will probably try to argue when it comes for enforcement that they didn't have an opportunity or equal opportunity to participate. So there are some drawbacks, I do admit, but you need to work, you need to plan. If they're not coming to it, then you go to litigation at that point of time. So like I said, there is no one size fits all. There are challenges or limitations, so it's that, but it is much lesser than litigation, and you need to carve out on those specific jurisdictions where you can't probably do the ADR. I hope that answers that question.
They've also, the same question gets continued in the next one where they say, what are the current challenges as far as known to you, in implementing ADR mechanism in the Indian shipping and logistics?
I think there are no current challenges. I think you could perhaps, like I said, if the industry says this is what my contract is, and if you incorporate it, I don't think there is a big challenge. The question is, when you're selling, you're more interested in selling. No one looks at disputes. That's the reason why it's known as a midnight clause. You only look at disputes very late. I would probably say you look at from the no, from the outset, so to say, look at from the front foot. So look at, at this point of time, they said, when you're going to contract, we're only going to contract on this basis. Otherwise, we're not willing to do it. And if the industry is aware and they agree, I don't think there's a problem on it.
Okay. So what role?
In fact, cargo interest might also benefit out of it. It is not only you. I think what happens is it works both ways. Sometimes, the carriers might also do wrong things. Like you hold cargo on lien, you may not have any contractual right to do it. So even the cargo interest can initiate or even detention demurrage. So my point is it works both ways, but it's a more fairer resolution of disputes. So it doesn't mean that ADR is, can put, it's not a positional power. You want to solve it. Sometimes because the delays which are there in the litigation thing, you are trying to find a process which is much more better. This is the process which you can carve out, make it better.
So the next question says, what role does ADR play in resolving disputes between shipping lines and freight forwarders?
I think, okay, invariably what happens is most of the bills of lading in all the international shipping companies, if you're as a freight forwarder, would already have a dispute resolution clause. But the local industry, if you have sufficient bargaining power, can actually go back to the ship, or what do you say, the carrier's agents, and say, listen, if there's a dispute, let us do it by arbitration as far as India is concerned. You could, irrespective of whatever clause, if you have a bind, you could do it. It's a question of negotiation if you do it, and you can tell parties in is for all. Uh, it may be difficult at beginning, but when parties see there's a benefit to all, I think they can agree. So you could have, like I said, industry-wide this thing. Why do you want to do it? Because when you have a dispute, sometimes you win, sometimes you lose. But let's have a fairer way. It's much more easier. And with developments in technology, you don't need to actually go to court. You can do it by online. You can do it in documents. So I think what you can do is to talk to all parties. Why do you want to do it? Took it from an industry thing. It's quite possible. And if you all do it, you'll probably find that instead of spending money in fighting, you will be spending money on better things, in doing more business.
Can ADR be initiated? Oh, that's already been covered. In what types of logistics dispute is ADR most effective?
I think in all disputes, I would say, if there is a contract, if you have an ADR clause, then it's always effective. So I think logistic disputes, I think it's best to have an ADR. I think in everything. I don't think there's anything which I can't say on this thing.
So the next question and last one for now is that, is it of any value to mention that a dispute resolution clause in a contract can be considered to be independent of the contract itself?
Yes, it's a very interesting question. If you look at an arbitration award, it is considered as a separate part of it. Even if the contract is not, if there are issues with the contract, you arbitrate that contract whether the contract has been formed or not. So that's a pretty so yes, it is considered as separate, but it depends on the seat on the seat where the contract is or where you have to look at it. If the contract has not really been formed, it could be argued there was no contract, the arbitration clause is not there. You need to look at the facts of it, but generally it is accepted. Then arbitration clause is a separate contract. I think the Indian Supreme Court recently talked about four different laws, interplay of laws in a arbitration clause. The law of the seat, the law of the contract, law of the, not the enforcement, the parties signing it, and there's one more there. So you need to look at it, but yes, it's considered a separate contract. And if you have a dispute on it, you look at the arbitration clause to deal with the dispute, so to say. I hope that answers this question.
Yes, it does.
It answers more than questions. It opens up our thought process and the whatever limited information that we have on ADR. It brings us a lot more information. At least I'm already thinking on a few things that we can look at, doing for AMTOI along with our extended board like Triple FAI and the other associations put together. And so, yes, I think absolutely wonderful that was. I think we had a great session.
A
There's
power
so much
packed
of
1 hour.
absolutely, and the more you get into it, the deeper it gets. So I'm sure we were only sailing right on top. You've taken us a little deeper into this whole perspective, and I don't know. I think we'll need a few more sessions with you with your knowledge, not only in ADR but the other subjects that are there, so that our members gain more, understand more, save more, and so
And
absolutely
also
wonderful. I'm
maybe
short of words. I don't know how can I praise you more. The more I'm trying to
No,
think
no,
about it, the
Harish,
more
Harish.
I am
uh,
going into
no, no,
a dizzy
I,
of things that you've put in that we've
no.
not even thought existed. So
Can I suggest? I'll be more happy if the Indian industry embraces arbitration. I think instead of getting, I think one of the problems, again, I'm not an Indian now, so I must be very cautious when I say. One of the problems is we get too much involved with getting a judge to deal with it. I think we need to look at it from ourselves. So instead of only looking at an arbitration clause, I'm sure people with gray hair like yours and like mine, I will not say Priya is a very young lady, but what I'm trying to say is with a lot of knowledge which is there, we can participate so that to make the industry better. And the disputes, if you can solve it within members, you can instead of spending that money and energy, it can be used to make it better. I think
I
there
so
are
agree with you.
so my
I
point
totally agree
is
with you.
instead of going to court, instead of going to this thing, is try to get more of your members get involved in this process, wherein in whichever form, even in mediation, when in arbitration, have you considered mediation? As an arbitrator, if someone comes, I'll probably ask parties, have you considered other forms? And if you want to consider, I'm happy to do it. So once you have this knowledge which is there, and a lot of your industry colleagues have this knowledge, they can help parties to solve it, and the industry can spend the money in better things than fighting with each other.
that's something
There's
I'm
just
going
one thing
below.
that I'm sorry, Priya. There's just one thing that still comes to my mind. The disputes that we as MTOs have is basically with shipping lines or carriers. And what happens in this is that, when you talk about arbitration and mediation, you are saying, oh, can we decide on both losing or both gaining? But what about the fact that sometimes, it's one of them who is right and the other is absolutely wrong, and then takes the route to mediation because it is the only way that the person who's wrong can save money. You know where I'm coming from.
I agree.
So
Okay, let me. I 100% agree with you. I think I'll give you a small example. Like I deal with disputes on a daily basis. If you have a claim of $10,000 or $100,000, it's not big money in the international scheme of things. People will probably look at commercial consideration to solve it. If you have a relationship with an insurer, life is not white or black. There are shades of gray. Yes. So you could always look at it. There's gray, but okay, you give the benefit of doubt. If you look at an insurance contract, there's always a benefit of doubt given to the insured. So even if you have a counterparty, you can't be 100% correct. There'll always be shades of gray. You'll give the benefit of thing because the amounts are not huge. You can afford it. You want to continue business. But if it is $1 million or $10 million, I don't think so. People will look at the straight contractual one. So the mediation part which you're saying, if it goes to 1 million or 2 million, the dollar sign is too huge. You'll probably say, sorry, your reinsurer or this thing is too much. We need to look at strong contractual point.
we are basically discussing this more from the SME point of view, because a lot of our members and globally also the forwarding community is more like a small and medium enterprise committee, communities. And looking at that, the kind of money that you sometimes, even if, like you said, internationally a 5,000 to a 10,000 or 100,000 is not big, but it is big when you are in a country, like India, where the exchange rate to a dollar is 1 is to 86. So it really plays that 1 is to 86 or 1 is to 88, whatever the number would be, and it could make or break a small company. So while we do understand that, internationally, when you're doing this business, these are the risks that you have to be open to. But it also is a fact that sometimes a company would have to close down because of something like this.
Yeah.
So the point is looking at it very differently, and not more on a dollar terms, but you look at it from an Indian rupee terms to understand that what can happen. It's just a thought that comes to my mind.
Harish, there are two. Okay, I'll give you an example of some claims which I'm involved and probably explain. You're exactly correct. 86 rupees to a dollar. I think Indian claims are not cheap. If you go to Supreme Court, I believe
It's
senior
murder.
counsel get in lakhs per sitting. So it's legal costs in India are not cheap. People think it's cheap. No, it's not. In fact, if you really look at the life cycle of a dispute, my view is Singapore's cheaper. I'm a Singaporean now, but don't misunderstand me. Here, what
No,
happens
no,
when you
no.
tell a date, we finish it off, we solve it. We are much more faster because we are a country with absolutely no resources except human, this thing, and we work hard. But India is blessed with this thing, but the costs are very high. That in the life cycle. But yes, initially this thing. Now, insofar as your members are concerned, if you have a dispute, and so far as cargo claims are concerned, invariably you will have a liability policy that triggers that will be dealt with it. It's only the FD&D when you have a contractual dispute, where, in my knowledge, there is very less cover available for the freight forwarding industry. So you would generally not have, so you need to go to a lawyer and fight it. That's where arbitration might be this thing where you can say we have a contract to do it. You can do it
Fair
yourself.
enough.
You can do it yourself. You don't need to go to a lawyer. I am not a lawyer, so I do arbitration for my clients, both as an arbitrator, as a party appointed representative. Rarely, but you can do it. But yes, you need to know the process. You need to be able to write. You need to Uncle Google is there. They can help you in that, and it is possible to deal with it. Now, insofar as disputes are concerned, what happens is, like, I'll give you a small example. You do a shipping from Singapore to or India to Singapore, and the vessels gets delayed. The immediate instinctive reaction from the cargo interests is, listen, I've got delayed, my contract got spoiled, or the cargo got spoiled. I actually have an issue in which a vessel had a GA, and the vessel reached after 4 weeks or 6 weeks, and the
Mm,
shipper is claiming, oh, this is actually a sensitive cargo due to delay. They loaded a normal GP box, and you need to pay for the cargo. Now, no shipping line will ever give committed delivery dates. It's all the ETA or ETD. So this is something which you tell, if someone keeps on doing it, go and sue us, go and arbitrate. It's okay. So when it comes to,
understand, yeah.
so you need to look at it, at least a binding one
Yeah, yeah.
works that way. If
Pragmatically.
people are not willing to, if you will not visit, go and that. But if people have something, oh, the container a whole, you had something where a fault, then you could probably say, okay, let us look at a collaborator. Let us collaborate on it and do it. So there
Fair
are
enough.
different ways. So I don't think it's a one size fits all, but you need
No,
to
no, no,
look at
it's
from.
not. I'm just putting the point of view, because when people are there, they usually, our members say, "Oh, we are SMEs." Don't look at it as, from a corporate point of view. So it's just to open up the eyes of people that, and our members, so that people understand that yes, we are looking at this, but what are the pros and cons of everything is to be understood also.
Yeah.
So yeah,
Even SMEs, if you look at the last year when Express Pearl got burnt,
yes,
I believe it
yes,
was a NVOCC's container which was on board. And
that's right.
it was from the Indian subcontinent region. I probably, so obviously the carriers would like to go after them, and whether they have gone or not, I don't know. I'm not involved in that part of thing, but it can happen when
I'm
something goes
sure.
wrong. It
Yeah, yeah.
goes.
Two sides of a coin, always.
All I
But
wanted to
thank you.
add is
Amazing. Huh?
from
Go ahead,
the
Priya.
training point of view is that in maybe one of the next sessions, if we could have few case studies be discussed to understand in depth what kind of resolutions were provided in the past for people to really understand. I think one of the questions was also on that, is that what kind, like probably more on the detailed case study, that this is what happened and this is what how the arbitration helped them. So if we could also take up some case studies in the future, not obviously today.
Happy to do that, Priya. My suggestion is, when you have it, why don't you look at ongoing cases in India, and let's look at for all the jurisdiction, which was, what is right for Singapore might not be right for you all.
Yeah.
Uh,
Correct.
so my point is, at least in the shipping, if you look at charter parties, arbitration is the in thing.
Is always there.
So
That's the first.
if
Yeah,
it's there by default, you would probably find a LMA clause or SCMA clause or HK mag or something. Insofar as your bills of lading, you can go and look. The PIL clauses there. I can tell you so many because I've written on that also. So my point is, you need to develop that because this is something we actually in the forefront trying to develop it. But like I said, you need to compare it to the existing processes. The
Yeah,
existing processes are, I don't need to say, I've been involved in a matter I think the Chandigarh court. It has not come for so many years. Something in Gujarat is not up till now. Every day the lawyer is coming. One lawyer is there, one other lawyer is not there. So it's still there for 3, 4 years. So
that'll keep going on.
great.
yeah,
Anyway, we won't keep you. You're in Singapore. We won't. I'm sure it's getting pretty late over there, so we
yeah,
won't keep you away from your long weekend, which starts on Friday. So thank you very much for
Thank you.
doing such a lovely presentation, by sharing such a lovely presentation, and of course explaining everything. And we'll keep, as AMTOI, we'll keep bothering you and asking you to help us and advise us. So yeah, thank
thank
you
you.
very
Thank you
much.
very much, Harish. Thank you, everybody. Pleasure speaking. Have a great evening.
Thank you,
God bless.
everyone. Have a
Thank you.
great
Thank you,
evening.
everyone.
Bye bye.